Thank you very much, and thank you, Balázs, for your inspiring lecture and the analysis of the relationship between culture and religion and the protection of Christian culture and state neutrality. Before I open the first session, I would like to welcome Professor Szilágyi, who is one of the organizers of today's conference. He is going to deliver the closing speech of the conference. Let me now open the first session, which includes papers dedicated to religious symbols in the public sphere in the legal order of 5 countries: Serbia, Czechia, Croatia, Slovenia, and Slovakia. The first speaker is Professor Dalibor Đukic, who is going to talk about the Serbian legal solutions. Our speaker is an assistant professor of church law at the University of Belgrade in the Faculty of Law, where he obtained his PhD in 2016. He also graduated from Aristotle University of Thessaloniki, Faculty of Theology. His research interests cover topics connected with religious freedom in its individual and institutional dimensions, as well as Serbian legal history. Before I hand over to Professor Đukic, let me remind that according to the program, every speaker has about 15 minutes for his presentation. Professor Đukic, you have the word now.
Thank you, dear Professor Stanic. Good morning, everyone. I will try now to share my screen because I prepared some one presentation that probably will be useful for you and for the audience. I hope that you can see now the presentation on your screens. Thank you again. It is really a special honor and pleasure to participate in today's conference. And I should say that it is always challenging to be the first speaker at the conference, and I really will do my best to present the results of my research. As the most of you already know, those results are the results of the research that I conducted as a member of the research group responsible for the topic freedom of conscience and religion. And that's why I firstly would like to express my gratitude to the Ferenc Madl Institute of Comparative Law from Budapest, Hungary, which is the initiator and coordinator of the Central European Professors Network. The issue of presence of religious symbols is extremely important, and its significance will increase in the future. Professors Toron and Durham from the United States have already noticed in their monography that one of the major areas where the difference between secularity and secularism has been evident in various legal systems around the world is in its attitudes toward religious symbols in public space. This difference between secularism and secularity, secularity as a principle of distinction between church and state, and secularism as a negative conception of separation between church and state, is necessary in order to understand modern church-state relations in general, not only when we are speaking about religious symbols and their use in public space. Religious symbols are present all around us, as you can see, and it could be said that wherever there are people, there is some symbol with religious roots. For the purposes of my research, the term religious symbol has been used for any symbol or all symbols which are linked to or inspired by religion or belief. Also, the meaning of the term public space should be understood in the broadest of the terms. So it includes not only state and public institutions, but all spaces, let's say, outside the private sphere and outside the inner space, inner domain of religious organizations. The use of religious symbols in the public sphere in the legal order of the Republic of Serbia is not regulated in detail. Among the legal regulations that we could mention is the Constitution of the Republic of Serbia and the Law on Churches and the Religious Communities from 2006, and also the Penal Code. But in practice, religious symbols are often present in the public sphere, in public institutions, in public, generally in public, especially in media. And this is a result of informal initiatives and individual expression of religious beliefs, religion or belief. Although there were individual attempts to limit the use of religious symbols in public, they have not received a judicial epilogue, nor has the legislator intervened by amending the existing legislation. I identified several different situations that generate ardent controversies related to the presence of religious symbols in public sphere. The first one is the display in the public sphere of symbols that most of citizens perceive as exclusively religious, like you can see here, icons, crucifix, statues of saints, etc. These symbols are often present in public sphere, public spaces, not only because of their religious meaning, but also because of wider historical identity and cultural significance that they undoubtedly have. The presence of such symbols in public space should not be mandatory, and it is not mandatory, of course, but neither it is feasible to leave it unregulated and open to potential abuses. When we're speaking about abuses, you can see pictures down on this slide where there are people that, let's say, abuse some religious, traditional religious symbols like a cross, star of David star, and etc. The second, let's say that the law should prescribe the conditions under which the symbols, which have, among other things, a religious dimension, can be used in public space, which bodies decide on that and how their decisions are implemented. This is especially important when talking about public offices, educational institutions, hospitals, but also companies in general. The second is the issue of wearing of religious symbols in public spaces. This is probably the issue that is more important for Western countries at this moment, at least. In the Republic of Serbia, no disputes were arising from wearing religious symbols in or specific clothing that reveals someone's religious beliefs in public. However, this area also should not be legally regulated. Certain religious practices may conflict with applicable law. You can see here the Article 8 of the 2006 Law on Churches that protects the official uniform and all its parts of the priests and generally of clerics and religious officials of any religion. This European practice shows that a certain way of dressing can be prohibited, even if it is a manifestation of faith or belief. Here, the legislator should apply a balanced approach by restricting the wearing of specific clothes of symbols according to the practice of the certain European countries and the European Court of Human Rights, but at the same time leaving space for expressing religious beliefs through religious symbols that do not disrupt the harmonious life of citizens. The third controversy is compatibility of the practice of construction of religious symbols and monuments in public spaces that have been financed by the government, local authorities, or state-owned companies with the principle of secularity and neutrality of the state. In recent years, the practice of building various religious symbols in public areas has been noticeable. It is most often about building cross symbols, chapels, public fountains with decoration that have religious meaning, significance, etc. In academic discourse, such practices are marked as a form of desecularization of public space. However, such facilities do not serve only religious purposes. It is expression of the culture and identity of the vast majority of citizens of the Republic of Serbia. You can see here on the picture the cross in front of outside of one of the cities in central Serbia, and raising this cross that was financed by the local government was the reason for many, let's say, different approaches by academics, but not by any court or any other, let's say, legal method of trying to solve this problem of raising that cross on public land with public money, let's say. The law should regulate the construction of such facilities, taking into account the neutrality of the state and equality of all religious organizations. At the same time, when drafting urban plans, competent authorities should take into account not only religious buildings in the sense of law on churches and religious communities. You can see here the Article 32 of the law that says that churches and religious communities can build on their own temples, other buildings for purposes of service and worship, but here should be added also religious symbols because that is the reason why we have those sometimes those problems, at least in theory. Lastly, but also most importantly, there is a question of whether the manifestation of religion or belief in public space is constitutional, or more precisely, whether religious services and ceremonies that include the use of different religious symbols and have been performed in public or state institutions violate the principle of state secularity. The answer to this question has been formulated by the Constitutional Court of the Republic of Serbia, which assessed that worship in public buildings serves to meet the needs of individuals who use the services of these institutions and does not violate the principle of separation of state and church. It is noticeable that many public institutions do not prescribe in their acts the possibility of performing religious rites at the request of the users of their services. Although those users can refer directly to the law, it would be desirable for internal acts to provide for such a possibility so that a large number of users of services of public institutions would be aware of their rights and how they can exercise them. In the Republic of Serbia, there are no regulations that explicitly prohibit the use of religious symbols. Unlike some European countries, there are no regulations that restrict the right to wear specific clothes or insignia that are related to the religious affiliation of an individual. Since the prohibition in European countries are mostly related to non-Christian religious minorities, one of the reasons for this difference is what we call autochthonous religious pluralism. Churches and religious communities to which the vast majority of believers in the Republic of Serbia belong have existed on its territory for centuries and generally share similar social values and culture. Like in many other jurisdictions, symbols simply are not religious symbols are not a major issue, at least not until the question becomes politicized. This situation could change in the case of settling a large number of migrants on the territory of the Republic of Serbia. Most of them are currently only passing through the Republic of Serbia because they are directed towards their final destination, that is European Union. However, if they remain or settle on the territory of the Republic of Serbia, there will be a need to regulate the use of religious symbols within the field of the state's margin of appreciation in order to achieve a legitimate aim, which is, according to European Court of Human Rights, preservation of conditions of living together as an element of the protection of the rights and freedoms of others. Although no discussion on the use of religious symbols in the public sphere could be heard in Serbian courts, such debates are part of academic and public discourse. The book chapter that I prepared and that will be published in the book that we prepare all together, for the first time will comprehensively and interdisciplinary deal with the issue of the use of religious symbols in public space in the legal order of in Serbia. And I believe it will be great contribution to the public and academic debate. I hope that I did not, I have still enough time just to thank Professor Sobjic and his assistant Professor Pontiakovsky, sorry for the pronunciation, for their efforts to organize this conference. And I hope that I will be able to answer to your questions during the debate, during the discussion, and I will be grateful to hear your thoughts and comments on this issue. Thank you again.
Thank you very much for your paper, Professor Đukic. The discussion, as you know, is planned at the end of the second session of the conference.